Under your question, how do these things make it to the petition for review stage? The next case, Nsimba v. Attorney General of the U.S. out of the Third Circuit, is such a case. It looks like on petition for review, Mr. Nsimba was represented by Dwayne Morris, which is a big firm. So sometimes that's how,
Yeah.
they get there. And this is just a mic drop of a case for Congo asylum cases. And give it a read. Anyone who's got a Congolese asylum case, they got to read it. I mean, the quote, "It is beyond dispute that the Democratic Republic of Congo has a history, pattern, and practice of persecuting political objectors," end quote. And it's a huge quote. And it's full of it. It's great on reasonable relocation, IJ's cherry picking the record, how physical harm isn't required. All these things, really many of the points that DHS usually argues and that IJs often rely upon to deny. Third Circuit's going through it meticulously, saying why that is ridiculous.
Physical harm too. I've had friends say like they push him. It's like the threat of harm is enough. It's like what is? Isn't that the case where you don't have to have necessarily physical harm?
It is threat of harm, and so that's always been the case for the future persecution. But if you establish past persecution, then the government has the burden to, and the burdens flip, and so you always want to be in past persecution territory. And there are some circuits, and now, and including the third, very expressly here and before, that says even past persecution doesn't require physical harm under the right circumstances.
Yeah.
I mean, the 11th Circuit has said that not being able to practice one's own religion is a form of persecution. That's not physical.
Yeah.
So this case is fantastic for a number of reasons. I highly recommend everybody listen to it or listen to the podcast episode where I try to quote as many things as possible that can be used in asylum cases.